Thank you very much. It is my pleasure today to introduce Dr. Andrew Torrance. Dr. Torrance is a renowned scholar. He currently holds a position at Kansas University at the School of Law there, but he has held fellowships or is about to visit a number of other institutions, including Northwestern University, the University of Washington, and later this year, MIT. He is the author of a number of widely read and widely cited publications in fields related to intellectual property, biotechnology, food and drug law, environmental law, and this scholarship is the basis for many of his speaking engagements. The scholarship is also based upon his practical experience. That experience began with his training in biology as an undergraduate student at Queen's University in Kingston and continued through his PhD in biology at Harvard. He's also a graduate of Harvard Law School, and that training positioned him well for a successful practice in biotechnology law with the world's largest intellectual property law firm, Fitch and Richardson. He was the in-house counsel with Inverness Medical Innovation and has entrepreneurial experience helping to start Sterling Medical Innovation. So today, during our post-lunch keynote, we will be treated to a Shakespearean presentation. And so without further ado, Andrew Torrance.
I just want to ask, how do I turn this guy off? Okay, great. Merci beaucoup pour l'invitation et l'opportunité de participer ici. That's the extent of the French. I apologize. I would struggle on. It would be humorous, but out of respect for those who can really speak the beautiful language, I won't go further. But thank you very much for the invitation. Thank you very much to Corinne Morin and indirectly to Jeremy for suggesting me. This is a wonderful opportunity. I've really enjoyed the morning, and I hope to share some thoughts about genomics and the law that perhaps are at the frontiers, at least with respect to mostly American law, though I'll touch on European law a little bit. It's a very, very exciting field for me to study because it brings together the twin backgrounds that I have. I loved biology. I did not go into law because I didn't want to pursue it. It turned out that there were all sorts of interesting legal issues that impinged on biology, and I had a wonderful PhD advisor who actually encouraged me to combine the two. The place that I went to school, if you showed any interest in anything other than your biology research, you were given about a week to clear out your space at the laboratory and find another sponsor. Fortunately, I had a very progressive and thoughtful PhD advisor who allowed me to cultivate these interests. I know how to spell the word tossed, by the way. I know that it's T-O-S-S-E-D, but Shakespeare spelled it T-O-S-T. And I thought that it was an appropriate title to explain where I see genomics at this current moment, especially in American law. This last year has been an especially tempestuous and, with respect to certain legal rights, dangerous year. And I hope to talk about this not only to depress and give you an example of what not to do, but also because I think that within the tempest there are a number of very interesting and possibly powerful opportunities for genomics and biotechnology more widely to move towards. So what I'm going to talk about today is very briefly the state of the technology, something that many people in this room know much better than I do. A little bit about the hope and anxiety that the public has, and it's a growing set of hopes and anxiety. I'm sure that this is something you're acquainted with in Canada. In the United States, this has reached a fever pitch. There are those who think that this is the messiah of science, and there are those that think this is Armageddon. So I think that it's good to bear that in mind as we think about how the law has adapted and maladapted itself to genomics. talk a little bit about regulation. Consumer genomics is something that is on the market in the United States. Increasing numbers of people are actually doing it and paying money for it, enjoying it, sometimes being horrified by the results. And the governments and the agencies at the federal level in the United States and mostly at the national level in Europe have decided to pay attention and to begin to regulate in an ever more active way. Genomics privacy is another issue which has reared its head. As the seas of genomic information increase in volume, states and the federal government in the US and at the EU level in the European Union and at the level of, for example, insurance regulation in places like the UK and Italy have started to pay a lot of attention to who gets to see this data and who gets to make decisions based on this data and what sorts of decisions are appropriate and inappropriate. Then I'm going to move a little bit towards what I think may be the frontier of law and genomics. I'm going to talk about what I call a human bar to patentability. And I'll spin that argument out a little bit. And I'm going to use examples not just from genetics, although genetics provides the strongest evidence for this argument, but also stem cells, diagnostic methods, and also in vivo products, drugs that are actually activated upon ingestion in the human body and attempts to patent such drugs. Then I'm going to talk a little bit about open innovation. Open innovation is a field and an approach and a philosophy that is capable of being applied to any technology. It has tended in the past to be applied to electronic technology, software, et cetera. However, there's been a rapid rise in the last 5 years especially in the application of open innovation and user innovation and collaborative innovation to biology, specifically genetics and genomics, which happen to join up with software in a sense because you're involved with a lot of data and in some cases data that can be used to carry out instructions in an algorithmic way in cells or test tubes, et cetera. Then I'm going to talk about something that you'll probably think is crazy right off the bat, but I hope to make an argument that it is not only not crazy, but it already exists in the United States, and that's DNA copyright. And the reason that I want to talk about this is that, just like the ship in the first slide, gene patents are experiencing a little bit of turbulence at the moment. And if it turns out that the Supreme Court in the United States or a brand new amendment, an adaptation of what's called the Weldon Amendment that was just incorporated into the new patent law 2 weeks ago in the US, it turns out that genes aren't patentable. It could be that there are alternative forms of protection, which may offer some investment prospects for industry, while at the same time balancing some of the rights that people have complained that patents don't offer. And so I will start by talking a little bit about what's happened in the last 10 years. Again, this is stuff you're familiar with, but I think it's important to set the context. The year 2000, we have twin winners of the genome race. We have, at the same time, a variety of companies that pin their hopes on single gene diagnostic tests. And BRCA1 and 2 have become poster children for this, both on the positive and the negative side, but also cystic fibrosis, Tay-Sachs, et cetera. These are probably all tests that anyone here who's had a child has had done, either at birth or sometimes before. Affymetrix, in a number of ways, Affymetrix has presaged a lot of the developments in genomics. They were the first company to put a genome on a chip. It wasn't a real genome, but at this moment, there actually is just about a real genome on a chip that several companies have offered commercially. Personalized genomics, a sort of unpredicted but increasingly powerful corner of the genomics world, including 23andMe, Sergey Brin's wife, Sergey Brin at Google's wife. The company's right across the street from Google. They share barbecues on Friday afternoons. They share investment capital. They share a lot of ideas and personnel. The promise behind this company, Navigenics, Nomi, Pacific Biosciences, Illumina, and Life Technologies, the latter two being purveyors of sequencing technology rather than consumer services. This has led to the idea that genomics is no longer a scientific enterprise. This is something that you can do as an individual, and your genome is something that you can know as an individual and perhaps own as an individual. Now, the $1,000 genome is a phrase that was championed about 10 years ago. Nobody's quite clear who came up with it. But Kevin Davies has written a wonderful book talking about basically the trajectory of costs of sequencing an entire genome, which at this moment, well, it's gone from $99,000 per full genome about 2 years ago to $50,000 about a year and a half ago. Illumina now does them for $10,000, takes about a week. Pacific Bioscience claims that it can do it for $1,000 in one day. And Ion Torrance, which announced its new product this fall to compete with Illumina, they claim that for $500 within the year, for $500 you'll be able to get your full genome sequenced in the doctor's office with their machine. Now, when I looked into their machine, I think their machine's a little bit of a fudge, because I don't think that it sequences the entire genome. I think that it looks at any actionable portion of the genome, and it skips over things that aren't well characterized. But even so, a doctor's visit, a pinprick, and then a printout, it seems like we've arrived at Gattaca in some ways. Then there's the synthetic side of things. Craig Venter, Drew Endy, George Church. There's a cast of characters who are pushing the boundaries of not just sequencing genomes, but rewriting them and making them from scratch, from genes to genomes to rewired cells, such as what Venter booted up a year and a half ago. And then there's the idea that was sort of pregnant within the synthetic biology world of democratizing this whole technology. Open user and collaborative innovation paradigms have become very powerful outside of the software universe. Eric von Hippel is probably the greatest champion and sort of the philosophical founder, I think, of this field. The BioBricks Foundation is an organization based at MIT and Cambridge, which offers little Lego pieces, each of which is a particular genetic module that you can click together in a molecular way to build funky organisms. And the iGEM, which BioBricks runs, it'll be, I think, the 6th or 7th annual will be this November at MIT, is the International Genetically Engineered Machines Competition. It's an Olympics to see if you can design genetically modified critters, which you synthesize as much as possible from scratch. And then do any search on YouTube, and you'll find all sorts of crazy bits of biotechnology, sequencing, synthesizing, being done in people's kitchens with regular kitchen implements, or, given the fact that the last 4 years has been such a disaster for biotech, biotech equipment grabbed from eBay or Craigslist. So I think genomics is a rather all-encompassing endeavor now, and it's not just policymakers and scientists who have an interest. There's a lot of people doing it outside of the policy radar and outside of the regulatory radar, and inevitably things will happen and governments will take interest. So I think that it's timely that Genome Canada has been putting so much thought into these issues. So the anxiety, I don't think I need to belabor this, but there is a wonderful quote from Michael Crichton, appeared in the New York Times, Sunday New York Times. You or someone you love may die because of a gene patent. Gene patents are now used to halt research, prevent medical testing, and keep vital information from you and your doctor. And then Kreis and Schlick, they sort of get more specific, and they say really what people are worried about is the visceral fear of corporate interest claiming ownership over our very bodies. Now, consumer genetics. Wonderful little ad from Pathway Genomics. This is how you feel when you get your genome sequenced. It's a completely liberating experience, and it allows you to run half naked across a beach. I don't know why anybody would not choose to do that. But Pathway Genomics, a pioneer in some ways, because Pathway came up with an agreement with Walmart about a year and a half ago to stock the shelves of Walgreen, a big chain in the US. I'm not sure if it's up here in Canada, but Walgreen's one of the two major pharmacy chains. And so Pathway Genomics and Walgreen decided they would market a special kit. It would cost $20 or $30 to buy, and then when you got it home, you'd have a choice. It's a spit kit. You'd spit in it in a vial, send it away, and then you had a series of options. You could have a test to see what your drug responses were to known drugs that interact, where there are gene indicators of interactions, or you could do the carrier test. You could test yourself for all sorts of genetic diseases, or you could do the health and disease testing, which is a more comprehensive battery of tests, or you could do ancestry. Ancestry is a really popular one. Or you could do the whole thing for $279. That is a bargain. You get the whole, all four of those things together for $279. Well, they stocked the shelves, and they were about to sell, and the FDA sort of went, excuse me, we're still here. And they contacted Walgreens, and they said, do you realize that this is a medical device, and that we regulate it, and that it is unapproved? And Walgreens suddenly shut its door, destocked all of its shelves, slapped the wrists of Pathway Genomics, and it didn't end up being sold to consumers in Walgreens. Now, this caused all kinds of controversy, both on the positive and negative side. There were those who thought, wow, just in time we took this technology off the market because this is a powerful, dangerous technology that people shouldn't have uncurated access to. And others thought, I don't understand. I thought it was my genome. I thought I was allowed to know about my own genomic information. How can the government tell me I'm not allowed to know that? But what this illustrated is that the technology is running far ahead of the law in the US, and it's, I think, more true in Europe than even the US. But the regulators are struggling to catch up with this. The Washington Post said something interesting about this whole schlemazel. They said, they're making medical claims. We don't know whether the tests work or whether patients are taking actions that could put them in jeopardy based on the tests. So this sort of encapsulated the worry that a lot of people had. There's a lot of tension between the folks that want to fully regulate and the folks that want to recognize perhaps a right to access information about your own genome. And by the way, the regulatory groups in the US that are involved in this, not just the Food and Drug Administration, but also the Federal Trade Commission, the branch of the government that deals with trade across states. So direct consumer is one model, and that's the model that Walgreens seemed to want to try. Another more curated option is physician prescription, where we allow physicians to decide whether it's okay for you to get yourself tested, and then presumably the physicians who spend a grand total of 41 minutes in their 4-year education, on average in the US, learning about genetics of any kind, can then tell you what it means. And as I said, the other alternative is the wild west of personal freedom and access to your own intimate genomic information. The FTC has published a number of guidances, one of which is called At-Home Genetic Tests. A healthy dose of skepticism may be the best prescription. You know, pithy, witty, and I think it telegraphs what it's saying about these sort of home tests. The FDA has set up a regulatory infrastructure, something it's very good at doing. It's got the Office of In Vitro Diagnostic Device Evaluation and Safety, or OIVD. The Secretary's Advisory Committee on Genetics, Health, and Society. I won't even try and pronounce that. And then it also has a panel of outside experts called the Molecular and Clinical Genetics Panel, which actually met in March of 2011 in response to a Federal Register announcement that they were going to set guidelines. And the result of the meeting was basically disagreement about how to regulate direct-to-consumer genomic tests. So it's still unclear how these things are going to be regulated in the long term. What is clear, however, is that the FDA and the FTC are going to regulate these as medical devices under the statute. Now, genomics privacy is another interesting direction that genomics and the law have gone, and a very powerful one that I think wasn't predicted by a lot of people, although looking at the cyber experience, perhaps people should have predicted that this would be important. The Federal Genetic Information Non-Discrimination Act, which everybody calls GINA, very friendly title, GINA. Do you know about GINA? You know? GINA is actually very unfriendly to companies that decide to use genetic information to make any decisions regarding their their employees. It's also very unfriendly to medical insurance companies that try and use genetic information to make decisions about coverage. So that's Articles 2 and Articles 1 of GINA's provisions. GINA is now fully enacted. The regulations are in force. And it's fascinating to see the ignorance out there among companies and medical insurers that the feds have already put in place a very powerful law. So there's a growing number of suits by patients and employees who are hearing from their employers that they need to get tested, or the employers during interviews ask them, now, have you ever had a serious disease, or do you have a history of breast cancer, or have you taken any genetic tests? These are all absolutely forbidden questions in the US at this point, but employers are only starting to catch up to the implications of this law. What they do, I think, recognize is a deep desire among consumers and patients to control the information from their genomes in some substantive way, and that they don't trust companies to do it or medical insurance companies to do it. They want the federal government to step in and use its police powers to ensure that this information is not used in a way that they don't support. Interestingly, the states have gotten into the act as well. It's unclear whether these laws overlap the federal laws to such an extent that they would be preempted by federal law. And I won't get into the gory details of federal preemption in the United States, but Vermont has proposed a Genetic Rights Act, and California has a bioinformatics bill, which goes even further. Massachusetts, fascinatingly to me, has a Bill of Genetic Rights. That's what they're going to call it, the Bill of Genetic Rights. And it doesn't address just privacy. It also addresses something that comes originally from an old case from California called UC versus Moore. And I don't know if folks have heard of this case, but long, long time ago, a patient in California had some interesting cells. They were removed by a doctor. The doctor decided these cells were interesting to culture and had interesting properties. And they ended up patenting these cells. Turns out the patient had signed a sort of a waiver saying that anything taken out of my body no longer belongs to me, but they took it to court. They said, look, these are my cells. They belong to me. They're part of me. You can't own them. You can't own a patent on them. In the end, the patient lost, but the principal introduced this idea into US jurisprudence. And what Massachusetts, in its Bill of Genetic Rights, is proposing is that your genes and maybe other parts of you actually belong to you. So it may be increasingly difficult, at least in Massachusetts, and if this is translated into the federal level all across the country, for people to try and own genes that are isolated from other human beings. You may end up owning your own genes and any intellectual property that comes out of them, something that's simply not the case in the US at the moment. So I'm going to talk a little bit about a trend which has been occurring both with genomics and other human and biotech-related forms of intellectual property. And this is, to those who've bored themselves with American cases, this is sort of a parody of anything under the sun that is made by man, the holding of the Chakrabarty case that made just about everything patentable. So let me start with the poster child for this little principle. In 1999, the European Patent Office issued a patent which was fairly innocently called Isolation, Selection, and Propagation of Animal Transgenic Stem Cells. Claim 1 was a method of isolating and or enriching and or propagating desired animal stem cells. That's not terribly controversial. Claim 48 was a method of preparing a transgenic animal. Again, this is sort of standard claim language. But the specification, the description of the patent on page 12, and the specification, again, for those who are fortunate enough not to have spent a lot of time thinking about this, specification can be used to breathe life into the meaning of claim language. And specification on page 12 said, in the context of this invention, the term animal cell is intended to embrace all animal cells, especially of mammalian cells, including human cells. I added the emphasis there. Well, if you then take the logic back to claim 48 and claim 1, these include methods of making humans. Well, this did not sit well, as I'll talk about in a few moments, with a number of authorities and citizens groups in Europe. But I think that it reflects a deep-seated worry and misgiving on the part of Americans, Europeans, and I suspect Canadians and Japanese and Australians, et cetera, about ownership of human-related inventions, or inventions that are intimately associated with the human body. In the US, there's a strong constitutional basis for patents. There's a claim that without patents, you get a tragedy of the commons. This, I would simply point out, is a highly controversial claim, and it is empirically undemonstrated. A number of large studies have come to consensus conclusions, including the National Research Council in the United States, that this claim may or may not be true, but nobody's ever shown that it is. So there's a lot of empirical work trying to go into investigating this claim. If it is true, and there's a certain, I think there's a certain common sense to it, if it is true, we probably want lots of patents. If it isn't true, then it does sort of reach back to this sort of grant. Why do we have this in the US Constitution and then in statutes in Canada, Europe, and other places if we're not quite sure that this claim is true? Well, it turns out that patents in biotech are valuable. They're very valuable. Sheila Jasanoff, in a nice piece of research, has demonstrated the connection between changes in the patent laws in the US and other countries that allowed the biotechnology industry to garner investments and to become a viable industry. Now, interestingly, although patents are extremely valuable to biotech, there is some other research that asks the question about whether biotech makes anything other than patents. Jonathan Golden at the University of Texas has done some research which he concludes that the biotech industry is exceptionally good at producing a particular product, and that product is patents. Biotech as an industry in the US has never made a profit yet. Now, there are certainly some companies like Amgen, Genzyme, Biogen, who have made profits, but the industry as a whole is yet to tip into profitability. It may soon, and having worked a lot for the biotech industry, I really enjoy that kind of work. I'm optimistic about a lot of companies and the contributions that they make. But patents do play a signal role in biotech, more important, I think, than a lot of other industries, and they act as value placeholders for products that are not yet ready for the market. There's all sorts of hurdles in patentability. These are fairly uniform around the world, but the one I want to talk about is eligible subject matter. In the TRIPS agreement, there's wide availability of protection for all sorts of different types of inventions, although there are certain exceptions like the ordre public exception or the morality exception. I like to think of this as people in the streets with pitchforks. It just really strikes them as heinous that something is going on, and so it disturbs the ordre public and it offends their morality. So you may remove certain biotech inventions from patentability if you want to invoke the TRIPS provisions. Most countries have not, but it is a possibility. It's recognized in the TRIPS agreement. There are specific exemptions possible for animals other than microorganisms and essentially biological processes for the production of animals. Now, Diamond versus Chakrabarty, the case that I mentioned that you're probably familiar with, at least in passing, it said there's certain things you can't patent, the basics like phenomena of nature, abstract ideas, etc. But you can, on the positive side, patent anything under the sun that is made by man. Pretty broad ambit for patentability. Specifically, in this case, they meant genetically engineered organisms and genes. Now, since Chakrabarty, I'm going to go directly against my thesis right here, and I'm going to say there have been lots and lots and lots of patents on human body-related inventions, lots of patents on human embryonic stem cells, lots on human genes, some on whole genomes. I once filed a patent application late on a Friday night for an Israeli company that was claiming 250,000 human genes. I wondered years later, when it turned out there were only 18,000, how those claims were going to fare in the patent office. But it was a very exciting night to file patent applications or patent application claiming so many genes all at once. Human thoughts, and specifically in the context of genomics, human thought patents having to do with diagnosis and using genomic information to diagnose diseases or conditions, and then to go a step further even and to optimize a treatment based on your diagnosis. There's lots of patents on those as well. And then there's lots and lots of patents on what I call products of in vivo conversion. These are prodrugs that exist outside the body that once ingested change form into the active form of the drug and become the actual drug. So there are companies that have filed many, many patents on the drug form that only achieves its active form once it's ingested and changed by the human body. So the infringement occurs in the stomach, in the bloodstream, or in the organ that it affects. So there are lots and lots of patents on all of these forms of biotechnology. There's, however, all sorts of potential sources for opposition for these kinds of inventions. A lot of countries, this is the European Patent Convention, so representative of about 36 countries, have provisions that specifically say you cannot patent the human body or things related to it. The United Nations has made hortatory statements that you shouldn't allow the patenting of humans or human-related inventions. The US Patent and Trademark Office, the European Patent Office, and both Presidents Clinton and Blair have all made statements that genes specifically and human body-related inventions in general are not the sorts of things that ought to have the strong monopoly rights associated with the patent. The second Bush, in his last State of the Union address, decided that Congress must pass legislation that bans unethical practices such as the patenting of human life. And his dream has actually now come true in the new patent reforms, which I'll talk about in a bit. I also want to highlight, but I don't want to highlight this in a light way, that the 13th Amendment may have something to say with property rights attached to human beings. Obviously, patenting is nowhere near the horror of human slavery, but the 13th Amendment does mention that involuntary servitude is unacceptable in the context of the American legal system. And it's a question, I think, whether a patent over a human body-related invention could possibly introduce an element of involuntary servitude. And if so, those types of patents would have a constitutional ban on them as well. Gene patents. 20% of human genes are mentioned in patents. It's usually bandied about that 20% of the human genome is patented. Untrue. But 20% are mentioned in patents. We've already talked about this quotation from Kreis and Schlick. They were especially worried about human genes, and the Michael Crichton inflammatory quote. Well, how have the courts dealt with the tens of thousands of human gene patents and genome patents that are issued or are in process? Now, the flood has slowed down. The peak of the flood of these types of patents was the early 2000s, and since then, companies have become much more selective in what they apply for, companies and universities and individuals, although gene and genomic patents tend to be company or university related. So there's a slowdown, but people are still filing these sorts of patents. Well, In re Fisher, a case in 2005 in the US, said that you cannot patent a fraction of a gene. You can't patent a part of a gene. So an express sequence tag, if it's not a full gene, fully characterized with a function attached to it, unpatentable subject matter, regardless of the fact that ESTs, I think most scientists will agree, can be very useful for all sorts of laboratory activities. But the court said, no, you can't patent less than a full gene. It turns out that there's been very, very little litigation over genes, despite the claims of some of the more hyperbolic critics. There's only been 6 litigations on 13 human genes ever in the US legal system, and not one of the 4,270 patents has ever been found to have been infringed or been the basis of a preliminary injunction. This is work by Chris Holman in 2007. He's updated it now. It's still as true as it was then. But this is sort of a fascinating conclusion because the rhetoric is quite contrary to this. The rhetoric is that these suits are everywhere and there's a freeze on research and people watch their shadows worried that they'll be sued by Amgen or Genzyme or the holders of these patents. Now, this animating fear has prompted folks like Xavier Becerra, a member of Congress from California, to repeatedly propose what he called the Genomic Research and Accessibility Act of 2007. It's a positively spun title that actually says you can't patent human genes. Well, this came to a head, as I'm sure you know, with the American Civil Liberties Union taking the side of a number of patients and medical organizations, including the American Medical Association, against Myriad Genetics, which actually owned patents that covered BRCA1 and BRCA2, 2 variants of a gene that may be a strong indicator of breast cancer and to a lesser extent ovarian cancer. And the ACLU sued not just the owner of the patents, Myriad Genetics, but also sued the US Patent and Trademark Office. So they sued Myriad saying, you can't own genes, gene patents. And And they sued the PTO saying, you can't give gene patents. Well, the ACLU said, for example, every person's body contains human genes passed down to each individual from his or her parents. These genes determine in part the structure and function of every human body. This case challenges the legality and constitutionality of granting patents over this most basic element of every person's individuality. Most people assumed this would go nowhere, that it would be dismissed. But on summary judgment, on the most initial stage of controversy in the case, the judge in a prominent district court, the Southern District of New York, actually sided with the ACLU in a slam dunk and said, genes purification from the body using well-known techniques renders it patentable by transforming it into something distinctly different in character. He was sort of lampooning the current state of the law. Many, however, including scientists in the field of molecular biology and genomics, have considered this practice a lawyer's trick, kind of a low blow. You know, for a judge to say it's a lawyer's trick, that circumvents the prohibitions on the direct patenting of DNA in our bodies, but which in practice reaches the same result. It is concluded that DNA's existence in an isolated form, the form that's used in claims, isolated or purified, alters neither this fundamental quality of DNA as it exists in the body, nor the information it encodes. Therefore, they, that is, genes, are deemed unpatentable subject matter under 35 U.S.C. 101. Basically, these are not the sort of subject matter that you can seek protection under the patent system, according to Judge Sweet. Well, in a little bit, I'll talk about the sequel to Judge Sweet's decision. A lot has happened, including the Department of Justice making a rather remarkable statement. The Department of Justice in the U.S. was actually the defendant in the case. And all of a sudden, they got religion, threw up their hands, and said, you know what, the ACLU's right. We never should have said that genes are patentable, but I'll talk more about that in a second. A few more surprises as well. Well, what about stem cells? We've seen that genes are not faring well in the courts. This patent I talked about at the very beginning of this section is what was called the Edinburgh patent, the infamous EP 0695351. Well, it was vastly cut back in an opposition proceeding in the European Union, or the EPO, and the scope of the patent was specifically changed to exclude human beings. So there's no possibility now that it covers human cells, despite the fact that it explicitly did when it was first issued. Now, what about WARF, the Wisconsin Alumni Research Foundation, which has a lockhold on U.S. embryonic stem cell patents? They had one of the original researchers, Dr. Thompson, who made some of the foundational discoveries in stem cell patents, patent his portfolio of discoveries. And they have a number of very powerful patents which have been licensed, for example, to Geron Corporation, a California stem cell therapy company. They received, for example, a patent in 2001 on primate embryonic stem cells, and more patents have followed. They've made WARF a lot of money. WARF is sort of seen as the great example of how to license your IP in the US, because WARF has become quite rich from this. Well, the Edinburgh patent, as I said, narrowed in opposition, eliminate all coverage of humans. What about in the US? Well, in the US, the WARF stem cell patents were challenged in a reexamination procedure. It's sort of a post-issuance procedure that allows you to present new evidence that this never should have been patented in the first place. There were several rounds of rejections, reversals, and new rejections, and the challenges continue. But what's sort of interesting is that at this stage, WARF's patents, all of them that have gone to final decision, have been found invalid. For a variety of reasons. The EPO continues to invalidate patents under EPC 28C because they are necessarily produced by, quote, destruction of human embryos, and this has led to also a sort of slaughter of European embryonic stem cell patents. So both the US and the Europeans, using different legal instruments, have eliminated a lot of the coverage for embryonic stem cell patents. So genes, not doing so well. Embryonic stem cells, not doing so well. Thought is unpatentable. This is clear, I think, to everyone in every patent legal system. But in the US, thought applied to diagnostics has been an especially thorny subject of inquiry. And it actually went up to the Supreme Court in 2006, a method of testing for a metabolite in a patient and then taking the high or low level of that metabolite and consulting a chart that said, if high, sick, if low, healthy. That was essentially the method of the patent. This went all the way up to the Supreme Court. The Supreme Court was on the verge of making what a lot of people thought was going to be a landmark decision, probably against this kind of thought patent. At the very last minute, in a very Byzantine maneuver, the justices decided that it was too early to think about this kind of case, and they kicked it back down. They said, we're not going to decide it quite yet. And in a blistering dissent to the decision not to hear the case, so it's not even a dissent, it's a dissent to a dissent, Justice Breyer and two others said these kinds of things are unpatentable, totally unpatentable, they're outrageous, they're a misuse of the patent system, and we're keeping our powder dry for the next case that comes up. Well, it turns out that case has come up. There's a long history in the US law of not allowing so-called mental steps inventions. But recently, a number of these mental steps inventions have made it to the Supreme Court. There's a case called Bilski, nothing to do with biotech, but Supreme Court gave some of the parameters of what sort of human thought patents could be allowed and not allowed, in this case, disallowing a method of alternative dispute resolution that took place entirely in the inventor's head. But Prometheus versus Mayo, which is a case a little bit like metabolite, except instead of just measuring a metabolite and then making a decision healthy or unhealthy, it takes the next step and says, okay, measure metabolite. If high, sick, give drug. Test again. If the drug has brought the metabolite down to the right level, good, you've optimized treatment. If not, give more of the drug. Keep repeating this process until you have modulated the metabolite to the right concentration. So this goes further than the metabolite case that was kicked down by the Supreme Court, but it actually got called up by the Supreme Court. It went twice to the Patent Appeals Court, the Court of Appeals for the Federal Circuit, twice the Court of Appeals for the Federal Circuit, which generally likes patents, said, this is patentable. The Supreme Court said, no, please reconsider it in light of our Bilski decision. They took it up again. They said, still patentable. And the Supreme Court, probably out of frustration, has now taken it up. I've not spoken to a single judge or scholar or practicing attorney that thinks this is good for these kinds of patents. These kinds of diagnostic patents, which would certainly encompass genomic information diagnostic patents, so using a marker in a genome to make some sort of actionable health decision. It seems clear that the Supreme Court is going to decide against these sorts of patents, or at least define what they are very, very strictly so that most existing patents like this will no longer be patentable, and in order to be patentable, you'll have to reach a higher threshold. So the Prometheus case is now in the Supreme Court. We'll hear before next June what the decision is. I don't think it's going out on a limb to say that this isn't good for those kinds of patents. And by the way, the Supreme Court in the US, although it's contentious in many other respects, on IP, they're almost always unanimous. Sometimes there are concurrences, but either through boredom or agreement, they don't seem to debate these IP issues too much. They come up with a decision, they all stick to it. So those kinds of diagnostic patents, not so patentable either. So we've got three categories that have been granted lots of patents that don't seem to be doing well. Let's talk very briefly about a fourth. Well, there are some substances that, when ingested or injected, change form, and the active form has traditionally been patented or patentable. Drug companies often pursue these in vivo forms as well as the prodrug forms to enhance their coverage. And some of these patents are on blockbuster drugs. The USPTO routinely issues them, and courts have quite often heard cases on infringement involving these sorts of cases. This is every single case that's ever dealt with an in vivo conversion product. And what fascinated me enough to study this is that in every single case, despite the fact that the courts often start by saying, no, of course, these sorts of patents are patentable because anything under the sun is patentable, but in this particular case, there's not enough evidence. In this particular case, the patentee behaved badly, so inequitable conduct, we're not going to allow you to enforce your patent. In this particular case, we found some prior art. In this particular case, it's obvious. Every single one of these cases, 11 out of 11, the courts have either invalidated or not enforced these patents, which means if you own these kinds of patents, I would not be too confident if you try and assert them against defendants. Courts don't like them. I hate to say this because it's sort of a bad joke, but I think judges have a gut feeling that this is not the sort of subject matter that ought to get patents. So there's an old principle in patent law, Canada, Europe, Australia, the US, called moral utility. The idea is that some inventions are just not appropriate for patenting because they're morally offensive. And generally speaking, the US has avoided applying such a rule explicitly. But what I suggest is that they have been doing this with respect to biotech patents for about 20 years. And when push comes to shove in court, judges will often not invoke the principle explicitly, but use it implicitly to invalidate or not enforce inventions that are too closely related to the human body. So I think there actually is ethical content to patent law, despite the fact that patent lawyers often congratulate themselves that they don't need to deal with issues of ethics. And very interestingly, I think, is this an amendment that has appeared in congressional riders in US law for 6 years, an amendment that keeps saying that you can't patent humans, eventually became part of the US patent law 2 weeks ago. It's now enshrined in Section 33 of the new act. And it doesn't just say that you can't patent humans. What's fascinating about it is that it's anything directed to a human or associated with a human, not just a human. I think this makes a lot of sense in light of the research that I've done, because I think that there's a deep-seated worry about intimately human body connected inventions. And I think that this finally gives voice to it right in the patent law. It's unclear how it's going to be interpreted, but again, I don't think that it will be interpreted in a favorable light to at least some categories of genomic and other biotech inventions. So I think that essentially there may be something like a human bar to patentability. And human genomic information, I think, might fall within this area, at least within the United States. Europe is much stricter and more explicit. The Europeans have simply come out and said, human-related inventions, you can't patent. And genomic inventions have not fared well in Europe either, especially when they're human-related. Finally, I want to talk about open genomic innovation. There's a couple of strands here. It's actually a comic book that appeared on the cover of Nature that talks about synthetic biology and encourages the whole world to just go and do it. Life is generally closed. Most organisms do not share and shuffle their genes, but a lot of organisms do. And sharing and shuffling genes is the basis for the biotech industry. Open source biology, by analogy, may be a spur that could increase innovation in genomic biology. Eric von Hippel, again, second time I've mentioned him, has been one of the champions of systematizing what we know about user and open and collaborative innovation. And I think that genomic information, being informational at least in part, and the techniques being relatively straightforward at least to some extent now, might be especially amenable to open innovation. Changes in intellectual property law may actually shift, may herald a faster shift towards open user and collaborative innovation in a way that I hope to show in a second. So we know that gene patents are controversial. We know they're not faring well, at least in the States and Europe. One possibility is that we could just forget about patents and have a commons. But don't forget the tragedy of the commons that we talked about earlier. It's quite possible that drug companies actually need patents to make the investments that they do in order to develop and bring drugs to the market. So what about gene copyrights as an alternative? If we're left with no patents on at least natural source genes, perhaps copyright might be a place to look. Trade secrecy could be another place, but we can't talk much about it because it's secret. And it would deny the public of a lot of information that patents are meant to spill into the public forum. Gene copyrights might be inexpensive and automatic. They might offer some protection for piracy. And they might provide a legal platform for open source biology. Patents don't work well in open source because even if you promise to allow your patents to be used, there may be other patents hanging out there, hanging out in the world that will trigger infringement if you try and develop a product. So it may offer, at least in the eyes of some, a more balanced and flexible form of protection. Previously, it's been suggested, I'm certainly not the first. It has certain advantages. There's a fair use exception. I realize in Canada that's fair dealing exception. Originality is a factor. So if you independently invent an invention, you're okay. Whereas in patents, it's strict liability. It doesn't matter whether you're independently invented. If you infringe whether or not you copied or invented it yourself. Now, one caveat that you're probably thinking if you know anything about IP is, what about functionality? Well, the functionality requirement, at least in US copyright law, has been interpreted as is the structure dictative of function? Is the structure, for example, of a gene, does that absolutely dictate its function? Are there no alternatives to that particular functionality? And the way that it's interpreted in non-gene cases, because there are no gene copyright cases, is that as long as there are some alternatives and that function is not entirely dictated by the structure that's copyrighted, there may be room for copyright. In fact, there may be considerable room for copyright. Synthetic biology might be especially amenable to copyright in genes. And there are examples, isolated though they are, of copyright already. There's something at MIT called the MIT Mystery Hunt. Every year, a group of people design a treasure hunt. And each clue is very hard to discover. You need to know physics and chemistry and math to figure it out. But in 2005, there was one called Shotgun Wedding, one clue called Shotgun Wedding, which was a bunch of A's, T's, G's, and C's. And the winning team figured out that if you translated that into a protein, used the protein codes, it actually gave you the location of the next clue. Well, Illumina, the leading company of DNA sequencers and a big player in genomics, they actually send out a letter along with their machines. I don't know if people here own Illumina machines, but you've received a letter, and the letter says that you have a limited license to copy their primers, but their primers are covered by copyright. They don't say patent, they say copyright, and they list the primers that are covered by copyright. And Illumina is a serious company. They're not doing this as a joke. This isn't like the MIT treasure hunt. Other companies have assumed that copyright exists to a certain extent for genetic information as well. This is not something that's reached the public consciousness or the courts, but I think it's something that may actually fit. Now, gene history has progressed from particle down to the idea of information. And information is something uniquely amenable to copyright. In the myriad case, to sort of tie the final strand of that together, the Justice Department decided that actually natural source genes should not be patentable. They said perhaps human engineered DNA molecules such as cDNAs could be, but not anything that is derived directly from a human. The PTO in the US was not consulted. In fact, they were surprised by this. Well, actually, they weren't. They were consulted. They were asked to sign on to a finished brief. They said, we won't touch that with a 10-foot pole. And the Justice Department said, well, we're going to file it anyway. And it will become the law that you need to enforce, so get used to it. So the US PTO turned around, having been the defendant, and suddenly had to take the position that actually natural source genes were unpatentable. First time in 25 years that this had been policy at the PTO. Federal Circuit, the Patent Appeals Court, reversed the myriad case. They said, no, of course, these things are patentable. The Prometheus and Mayo case was taken up to the Supreme Court, and it looks likely, I think, that the myriad case will be taken up by the Supremes as well, put together with the Prometheus versus Mayo case, and made into sort of a grand statement about biotech patent law. And again, I don't think that if the Supremes take it, it will bode well for gene patent rights in the US. And as I mentioned, the Weldon Amendment is now in the patent law. And there's also a provision in the new patent law that says that gene patents should be studied for 3 years to see if they have a net benefit or a net cost. And it'll be fascinating to see what the result of that study is. I don't think it's a foregone conclusion which way they're going to come out. Synthetic biology, I know Genome Canada has dealt with this before. The idea of developing things from scratch instead of using natural source. There's all sorts of synthetic biology before the last 5 years. Relies on things like rapid sequencing methods, DNA printing, and full genome sequences. There's a spirit and ethos in synthetic biology that this should be democratized and opened and made available to the millions. And the BioBricks Foundation has done this in a couple of ways, or acted in favor of this in a couple of ways. They have a registry of standardized genetic parts, or standardized biological parts, and they run this iGEM Olympics, the International Genetically Engineered Machines Olympics that I mentioned. And their ethic is that open works better than closed. They have a number of philosophical things they believe in. They want things to be used. They want to program life. They think that's a good thing. They want to rely on standardized parts like Lego pieces so everybody can use them. And they want innovation to be open. The registry of standardized biological parts has a lot of parts in it, about 3,200 at the moment. It grows by about 1,500 a year. It has a standardized format for snapping the pieces together, obviously not literally, but easily putting them together in the laboratory using standard techniques. You have to specify how the parts, you have to specify the parts and characterize the parts, and they have to fit together in a standardized way. And this is one of them. This is a LASAR activator that's in the Registry of Standardized Biological Parts that if you join the International Genetically Engineered Machines Olympics, they'll send you this and all 3,200 other parts or specifications for building them, and then you use those to build your genetically engineered machine. The Olympics is fascinating because it draws participants from 39 countries last year. It'll be probably more like 60 countries this year, and more than 1,000 participants. These are mostly undergrads. These are not professional biologists. And they build crazy things like bacteria that smell like bananas, or an LED screen made up of yeast that bioluminesce if you zap them with electricity, which I think is mean. But if you zap them in the right way, the yeast can actually make patterns on a screen. And if you need a bigger screen, you don't have to go down to the store. You can just grow your screen. Just give the yeast what they need to grow, and you can have a bigger screen. As I mentioned before, one possibility is that this could all work on the principle of a commons, where there's no IP protection whatsoever. Everybody can use it. Everybody can own it. It's just free for everyone. Sort of like open source software, or free software in the ideal sense, where there's no copyright protection. There's lots of risks and uncertainties in this, not least of which is that it would be less regulated than a system that has legal rules involved. But even those involved in synthetic biology have said, we really do need to have some law. And one possibility is something like an open source license, currently used for software, but adapted for genomic information. There's a lot of challenges in making a license. DNA's never been considered copyrightable before, although it's been considered patentable. It doesn't work as well with patents, but might work better with copyrights. But given the fact of the ACLU versus Myriad, the Prometheus case, the Weldon amendments, it may be that patent rights have withered to enough of an extent that copyright may be a valuable path to go. A license can provide a number of signals about what you're trying to achieve in a field. It can act sort of like a constitution. There's a number of values that make a good license, at least in the open source context. And there actually is a license now for genomic parts or genetic parts. It's called the BioBrick Public Agreement version 1A. I worked a little bit on this with the BioBricks Foundation. There's two agreements, a contributor agreement and a user agreement. And this is now up on their website and available for signing and for use by groups that want to share parts. So patents are different than copyright in a number of different ways. I think I've already talked about that. DNA is actually not nearly as crazy as a source for copyright as you might think. It's either analogous to software, which I think is certainly true, or it is software. It's just software that is not ones and zeros. It's A, Gs, Ts, and Cs. Cells are analogous to computers, but maybe in some ways they are computers. Crick seems to believe that genes are computer programs and cells actually are computers. In fact, he says you can't understand life without accepting that fact. DNA copyright applies fairly well or copyright applies fairly well to DNA, and let me just parse it a little bit. Original works of authorship. If you write a gene, it's an original work of authorship. Fixed in any tangible medium of expression, now known or later developed. That language is beautiful for things like DNA. From which they can be perceived, reproduced, or otherwise communicated. That might be a problem because it's hard for us to read DNA except either directly or with the aid of a machine or device. That saves it. Fixation may occur in any form, manner, or medium, sufficiently permanent or stable to permit it to be perceived, reproduced, or otherwise communicated for a period of more than a transitory duration. So superficially, DNA would seem to fit the copyright statute. It certainly seems like it could be a literary work. 17 U.S.C. 101 says, literary works expressed in words, numbers, or other verbal or numerical symbols or indicia, regardless of the nature of the material objects in which they are embodied. And the include is meant to be illustrative and not limitative. Expressly so. That's what Congress said. This is just a list of examples. So I think DNA actually fits rather nicely all by itself, but it could also use help from being considered analogous to software because software is expressly included in copyright protection in US law. So if DNA is software, and the BBF says this, one can program living organisms in the same way a computer scientist can program a computer. Then DNA may either be analogous to software or software per se. If a gene is software, I just inserted a few words to sort of make more explicit sense. A gene encodes a set of statements or instructions to be used directly or indirectly in a cellular computer in order to bring about a certain metabolic or signaling result. So the result of accepting copyright as one form of protection for DNA may be that it opens the door to a more open form of genomics research and development. Copyright law limits monopolization of function, which answers some of the critics. It's not so happy for biotech companies that want to own the function. Originality allows independent authorship. So if you have a clean room, you could re-engineer the same solution in the same way as long as you didn't copy it. And fair use for example, criticism, comment, news reporting, teaching, or research is not an infringement of copyright, provides a wide flexibility for those that want to tinker with genes in a non-commercial, non-market-threatening way. Privacy would be discouraged under this form of protection. And as I said, it might enable an open source licensing legal framework, and it could spur innovation in genomics, for better or for worse, to the same extent that currently open source software seems to promote some types of innovation, such as server software and a variety of other applications. Now, this might be a good thing, might be a bad thing. Maybe we don't want wide open innovation in genomics. Maybe that's a scary prospect to folks. So to conclude, progress right now is quite challenging on the technical side. Lots of hopes and fears. There's a regulatory scramble both in Europe and the US around consumer genomics, personalized medicine, and the issues of privacy and also property, including intellectual property. Patents have experienced probably the worst period of their history in biotech in the last year that they've ever had. Genes and genomes, there's a big question mark over the patentability of at least some forms of those. Diagnosis and treatment, ditto. And DNA copyright, for better or for worse, may be the best form of protection if the worst case scenario of patents on genes comes true, if the Supreme Court takes up Myriad and gives a negative answer. Synthetic biology is one of the tremendous areas of ferment and innovation, and in fact answers some of the patentable questions you probably realized. If you design something from scratch, then it may not apply to the same principle that says that natural source genes are unpatentable. If you've made it from scratch, it's not isolated, it's not purified, it's a new invention. And the whole idea of democratized innovation, bringing open innovation to a closed field, encouraging many, many users instead of a small number of professionalized users, and encouraging things like collaboration made possible by things like open source licenses. This, I think, is at least part of the future of genomics under the law. These are some sources if you're interested in boring yourself further. And with that, I'm done.
I don't want to be the only person making a tough decision here, in that that did run a little bit longer, but it has spurred many questions in my own mind. And so I wouldn't want to frustrate the audience by not allowing a few questions. And then we'll see. We might get a few highlights from tables. We get a little bit of plenary discussion. Those who have to leave, as we had said, the event would close around 2:30, 2:40. I would respect that. And those who want to continue a little bit, some of us still have a little bit of energy to sustain a little longer conversation. But if there are some questions, I think this was a really terrific talk. For those who attended the first event, sort of really continues to push our thinking about intellectual property. If that's the starting point for much of the thinking of commercialization, if we're going to pull that rug from under their feet, wow, are we in a very open, creative period of time for science and all that is related to it in terms of law and policy. So, some questions. Peter, please go ahead.
Andrew, I'd like to ask really a bridging question from what you've talked about to the discussion today, and that is that much of what we talked about is that patents are a critical part of commercialization. You're talking about the limits and possible extensions of different forms of property rights, including patents. What's your take on what it means for the commercialization of technology coming out of the genomics world?
I think the simple answer, and this is sort of an instinctive answer from somebody that practiced patent. I mean, I still do practice biotech patent law. I filed an application last week on an invention that my talk probably dooms. I think that the conventional view, and it's a pretty powerful view, is that biotech companies really will cut back on commercialization if they no longer have strong patent protection backing their products. One of the nice things about biotech patents is that they're often discrete. It's fairly clear to know what those patents cover. One of the critiques of patents in general is that it's unclear where their boundaries are. At least biotech patents seem to be clear. There's a lot of evidence that biotech patents have net benefits over costs. There's a great analysis by Besson and Moyer in Patent Failure, I think that's the name of their book, that says that although patents seem to have net costs in almost every area of technology, in biotech, there's actually net benefits. So I don't want you to interpret my talk as being in favor of abolishing anything. I sort of feel more like an observer. I think that it's not looking good for strong patent protection for all biotech inventions. And in fact, I think there's a large subset of biotech inventions that may be floundering right now. But without patent protection, I don't see companies spending the at least hundreds of millions of dollars to bring products all the way through the regulatory process. And that may necessitate a different model, subsidies, for example, or something else that's come up that may answer this problem is the new biologics legislation in the US, where in return for allowing a generics pathway for biologics, the biotech industry, I think very savvily, if that's a word, managed to negotiate basically a new trade secrecy provision where they get to have data exclusivity for a long period of time. So although they might lose patent protection, if they're the first to develop the product and bring it to market, they don't have to share their regulatory data. And although small molecules, you can use the same, I mean, the data is fairly easy to replicate in general. For proteins with folding, secondary, tertiary structure, that data is incredibly powerful as a piece of intellectual property. If you're a company that doesn't have to share that with the generics, although they're able to make the generic, they have to basically replicate the entire research and development process from beginning to end. So there might be alternative forms of protection, such as data exclusivity, which I think to some extent are worse from a social perspective, a social welfare perspective, than patents ever were. But somewhere, somehow, if we're going to have a biotech industry and a genomics industry, there must exist ways of getting your investment back without subsidization. And if that needs to exist, the law is going to have to evolve certain mechanisms to protect the information. If it's not patents, I predict it'll be something else, but it may not be pretty, and it may not be as good as patents were.
Okay. Maybe you partially answered my question. I'm not from the law background. I'm from health background, so I might use the wrong words.
Sure.
But I was reading in a drug development that there is a possibility, instead of patent or copyright or whatever you call it, that I would call it exclusivity. So as a company, you get 1 year or 2 year, whatever, that nobody else can come in. Maybe that's what you just explained. So that's one comment or question better. And then I was expecting when you launched on the patent law that you will mention, I was exposed in 70s when I was in New York to, there was centennial of Tesla. And there was the whole issue about patent, non-patent. Not to speak about chemistry, which my father was. And imagine if every chemist patented every new element they discovered. But let's go back to Tesla. So what's happening? That was the alternative. It very well developed electricity and the bulbs and everything developed very well, although Tesla gave up the patent. And so I was hoping you would reflect on that to give another perspective of sitting or not sitting on data, because I'm personally biased by wanting to have open.
Sure.
So there are two questions.
Okay, no, those are great questions. Now, the first one, I love the first question. I think I partially did address it, but in general, I think your point is a really good one, which is, let's say we don't have patents. Perhaps we could use other parts of the law, such as the regulatory authority of the FDA in the US, or equivalent European authorities, or equivalent Canadian authorities. They are the gatekeepers of medical products. And so even without patents, if you're the first person to get through that regulatory phase, the drug agency could simply say, fine, you're the first one through, we're now going to give you a period of exclusivity, whether it's 2, 3 years, or 10 years. In fact, the first generic company to develop a generic now gets a mini patent of 1 year, well, sometimes more, and they don't get it from the patent office, they get it from the FDA. So that could be an alternative, and it would be a fairly easy alternative to implement. It would just mean change of a couple of words in the statute. So it would be like a patent, in some ways even better than a patent, and it would give the kind of monopoly that a patent does, but it would give it at the end of the process of development rather than at the very beginning. Now the second one, so I eliminated 30 slides from my show that were right on the stuff you were talking about. Thank goodness I did, right, Karine? I've done a lot of research on this area. I think it's a really fascinating area. Let me just summarize what I think that I've learned about it. I don't think there is a clear argument one way or the other across all industries about whether patents are good or bad for innovation. I think this is actually a question that we need to start addressing in a serious way. The US commissioned the National Research Council, a group of scientists, to study this issue about 8 years ago, and they did. And they came up with the following sort of surprising conclusion. They said the evidence that patents spur innovation is emergent, which is a nice euphemism for, wow, there's no evidence that patents spur innovation. Now, I'm not saying that patents don't, and there's some evidence that patents work well in biotech compared to other areas. But it strikes me as odd that in 2011, we are relying on a strong form of industrial policy, the patent, that we haven't proven yet actually drives innovation. And people like Eric von Hippel and other theorists of innovation, open innovation, say, actually, it squelches innovation. And there's all sorts of interesting historical examples. Italy, Switzerland, and Germany, for example, at various times turned their patent systems on or off for chemicals. I don't know if you're aware of this. At certain times, Germany had no protection for drugs. And then they brought protection back. And then they dropped it again. And then they brought it back. Surprisingly, though, and this is in work by Boldrin and Levine, the rate of innovation of drugs from Germany doesn't seem to have changed whether they had patent systems or not. So there's a lot of conflicting evidence, and I'd say that this is a wonderful field for people to start studying, because I don't think there's a clear answer in favor or against patents. And it's just remarkable to me that you can say that in 2011 when every country in the world almost has a patent system instituted by treaty.
Yeah, thanks.
I think we will thank Andrew tremendously for this talk. Very stimulating. But we will take away a little bit of time or reclaim a little bit of our time because I did want to hear back from table discussions. And so if those brave folks who have stayed around have gathered a few thoughts on paper, would be willing to stand up at either one of the microphones and let the authors of the brief know how discussions went about at their table regarding the few questions that were posed by the authors as they try and take all of the input they've heard from commentators, from some of the questions, and perhaps now from some of the little bit more diverse viewpoints from around the table. So do I have one or two volunteers to try and add a little bit to the input from the discussions at your table? Anyone would take on that role?